This will be a review of what we discussed. Countless times I discussed this because this is very important. Okay, so we'll start first with the definition of administrative law. So we'll be discussing today the topic on administrative law. So it is a branch of modern law which under which the executive department, okay, of the government acting as its quasi-legislative and a quasi-judicial capacity interferes with the conduct of the individual for the purpose of promoting the well-being of the community. So basically it's under the executive branch. So, and remember the two words here which most of the cases revolves around the function of being a quasi-legislative and a quasi-judicial capacity. Okay, when we say quasi-legislative, that administrative body has two functions, one being partly the one that makes the law, and the other one also has a color of a court. We call it as the quasi-judicial body. So going back to the structure of government, there are in a democratic country where there are three powers vested in the three different departments. One executive, one is legislative, and the other one is judicial department. Okay, executive, the one executes the law. Legislative, one that makes the law, and the other one, judiciary, one that interprets the law. So of this, the executive branch has, through its administrative agency, has a dual capacity. Okay, it may make a law, okay, on that particular aspect of the law which should be implemented. If it's not clear, then they can pass a law. We call it as a quasi-legislative, and the other one, it also functions as a quasi-judicial capacity, or it will make judgment. Okay, so making the person who violates under that branch administratively liable. So administrative law is the law concerning the powers and procedures of the administrative agencies, including especially the law governing judicial review of administrative actions. Okay. Now, what are other important things about administrative law? Okay, this seems to conform with the understanding of the area of the law of the Philippines. Administrative functions are those which involve the regulation and control over the conduct and affairs of individual for their own welfare and the promulgation of the rules and rule making. So administrative agency in general, okay, this is a creation of the executive branch to effectively do or execute the law passed by Congress, as Congress pass its execution to the executive branch. So Congress makes the law, but the execution will be under the executive branch. If the president himself cannot do it, then he can create an administrative agency. So it is the term generally to describe an agency exercising some significant combination of the executive, okay, legislative, and judicial powers. It is a government body charged with administering and implementing a particular legislation. So to simplify, when you say administrative agency, there is a law passed by Congress, but for its implementation, if it's difficult for the president himself to do it alone, then he can create administrative agency, as many as he can. Okay, and the purpose of that administrative agency is for the execution of the law passed. Now, so we go to the historical considerations of that administrative agency. Okay, why did administrative agency come about? Okay, so The one is that of the growing complexities of the modern life. So it has no other option but to make some administrative agencies. So because of so many needs, so many problems arises or criminality, then Congress pass a law, but for its implementation, it creates an administrative agency. So number two is the multiplication of the number of subjects needing government regulations. Okay, so because of the numerous people, okay, because of the increasing population, then it creates administrative agency for their acts to be regulated. Okay, number three is that increased difficulty of administering laws. Okay, so those are the three reasons why administrative agency come about. How about the question on why administrative agency is needed? Okay, so one is that because of the time element. Okay, number two is the expertise, and the other one is the organizational aptitude for effective and continuing regulation of the new developments in society. So in the end, summing all up, it basically an answer to the needs of the time. So there are definition which I would like to simply discuss, or perhaps it's just a matter of reading, but for those who do not have the copy yet, I'm going to read the basic terms that we will be meeting every now and then as we discuss administrative law. Okay, like the term agency, okay, it simply means that includes any department, bureau, office, commission, authority, or officer of the national government authorized by law for or executive order, okay, to make rules, issue licenses, grants rights or privileges, and adjudicate cases. So take note of these words: issue licenses, okay, and the other one, adjudicate cases. So what do you mean by adjudicate cases? What function? Okay, going back to the definition of administrative law, adjudicate cases, this fall under quasi-judicial branch or quasi-judicial capacity of the administrative agency. So that administrative agency actually has dual function, one that makes the law. Okay, if you violate that law, then it also has that adjudicatory power. Okay, so it adjudicates, meaning it serves as a court to determine whether you are violating its rules or not. So now it's important to know its difference because there are different remedies that you have to apply. Like for example, if the agency acted on its adjudicative power or adjudicatory power, then your remedy is to go to court if you think that the judgment of that administrative agency is in violation of the law that they created, and you think there's a grave abuse of discretion or an abuse, or the judgment is not in accordance with the law or any principles of law, then you go to court. Okay, you go to regional trial court or municipal trial court, as the case may be. Now if it's a function on legislative, okay, on its lawmaking power, then you don't have to go to court. Why? Because court has no jurisdiction over it. Okay, unless if there is really grave abuse of discretion or the law created is in a violation of certain laws, then the remedy is not to go to court, but perhaps for to clarify legislation. Okay, because you can only go to court if the function of the administrative agency is on the interpretation of the law they made. Okay, so research institutions with respect to licensing functions, government corporations with respect to functions regulating private right, privileges, occupation, or business, okay, and officials in the exercise of disciplinary power as provided by law. Now, administrative agencies are the organs of government, okay, other than the court, okay, and other legislature, okay, which affect the rights of the private properties either through adjudication or through rulemaking. Okay. Now, another question that may arise, okay, in discussing about this administrative agency, okay, is the question when, okay, is an administrative agency. When can you say it's an administrative agency? Okay. So, the criteria that you have to set in order to determine whether it's an administrative agency is when its function is primarily regulatory. Primarily regulatory, okay? So, even if it conducts a hearing and determines the controversies to carry out its regulatory duty, if the function is for regulation, okay, then it is an administrative agency. Now, the ever-increasing variety of powers and functions given to administrative agencies, okay, recognizes the need for the active intervention of administrative agencies in matters calling for technical knowledge and speed in the countless controversies which cannot be possibly handled by the regular courts. So what is the implication of this one? The court always respect the decision of the administrative agency, okay, being the body that has the know-how. Okay, so what does that mean? Most of the times when a case filed in regular court, especially in administrative cases, the court will remand the case to the administrative agency. Okay, why? Because that administrative agency has the know-how or the technical knowledge and speed in countless controversies. So courts may be expert in the general principles of the law, but as to the technicalities of how the rules crafted by the law by the administrative agency on its quasi-legislative function, then it is the administrative agency has the power, okay, and may not be the court. Now, if you file a case against a person who is under the executive agency or under the administrative agency, do not go to court yet, okay? You have to exhaust first all administrative remedies. What does that mean? You file first your case to the agency where that person belongs, okay? Because generally, when it is filed directly in court, then the court will remand it to the technical body or the administrative agency because they have the knowledge and expertise as to its technicality. So that going directly to court may violate the principle of administrative exhaustion of administrative remedies. Okay, so generally, whatever the decision of the head of the office or the head of the agency is will be carried in court. Okay, so there are actually cases which may be tried both regular court, administrative agency, okay, or even in the ombudsman. Okay, but the rule in court where if a court has exercises its jurisdiction, the one who took cognizance of the case excludes other courts. Okay, so if the case is filed in the ombudsman, then Civil Service Commission or any regular court will have no jurisdiction, being the case filed first in the ombudsman. Okay, so there are actually cases where an act may be punished by different courts or quasi-courts or quasi-legislative bodies, okay, or quasi-adjudicatory bodies. Okay, for example, one act of a government employee may be both criminal, which may be tried in the ombudsman, or ombudsman has the jurisdiction over the case, or it may be the Civil Service Commission has take cognizance over the case. So, but in any case, if it's admitted, or when the ombudsman took cognizance of the case, it excludes civil service. Okay. Now, on its rule-making authority, okay, so this is another function of the administrative agency. As I've said, it also has its rule-making authority. What does that mean? It is like quasi legislative. It can make a law. Okay, so going back, it is a branch under it's an office under the executive branch, but it can actually make a law. Okay, which is actually a color which belongs to the legislative branch. So in that case, if it's function as a rule-making authority, okay, it is administrative when it does not have the discretion to determine whether the law shall be merely prescribes the details for the enforcement of the law. Okay, so it just simply makes the law, but as to how it will be executed, it has no power to do that. Okay, that is its function. Okay, being an executive, but it can actually make a law on how it will be implemented. Now, there are kinds of administrative agencies. One is that a government grant or gratuity, okay, or special privilege. So, examples, we have a Bureau of Lands, okay, the Philippine Veterans Administration, GSIS, SSS, PAO, Public Attorney's Office. And then we have the carrying out the actual business of government, okay. So, we have the Bureau of Internal Revenue, okay, the one that collects taxes in the Philippines, and Bureau of Customs, or their duty is collect taxes from commodities or goods coming from other countries importing to our country. Bureau of Immigration, okay, Bureau of Registration, Land Registration Authority. So for service of public benefit, the one that will benefit the public, we have PhilPos, Philippine National Railway, okay, National Food Authority, National Housing Authority, MWSS. I think this is the sa water, no, Manila Water Service. And we have the regulation of private businesses and individuals, okay, the Securities and Exchange Commissions for all corporations. If you do not obey the Securities and Exchange Commission on its rules, then the SEC will not grant you the power to operate. So all companies must be registered in the SEC. So how about for the adjustment of individual controversies? Okay, so we have the National Labor Relations Commission. We have the Employees Compensation Commission. Okay, if you retire or if you meet an accident while in the engagement of the employee or employer, like when you are working and you commit accident, you become permanently disabled, then you can get a pension from the Employees Compensation Commission. Then we have the Securities and Exchange Commission for SEC, and then Department of Agrarian Reform for lands that are under the agrarian reform to be distributed to farmers. And then Commission on Audit on Government, that makes sure that government fund is indeed used for public service. Okay. And then we have the control of administrative action. Okay, one, president executive power. So president exercise over the acts of the employees, or under the, I'm going to charge. So the appointment of the administrative agency is through the president, subject to the approval of Congress through Commission on Appointments. Okay, so you've heard of Jenna Lopez, the ENR. She was appointed by the president but was not approved by Commission on Appointments. Okay, so while she was serving the DENR, while waiting for the appointments, of course, she acted as with the color of the office. So meaning all her acts are valid. Okay, so that is a de facto administration. So meaning he is entitled to the salary even if it's not yet approved by Congress through Commission on Appointments. Okay, the president. Okay, the executive powers will be vested in the president of the Philippines. So the head of all those agencies is the president. The president shall have control of all the executive departments, bureaus, and offices. Okay, so he shall ensure that laws are faithfully executed. Okay, and then he has also the power of control, which means that the power of the officer to alter, modify, nullify, set aside what the subordinate officer had done, okay, in the performance of his duties, and to substitute judgment of the former for test of the latter. So memorize this definition, because countless times, and even in our quiz, I'm going to ask this one. What's the meaning of control? Okay, the president, being the head of the executive department, has the power of control over the different department heads, the different secretaries. Okay, like Secretary of Education, Secretary of Health. Their decision is valid if it is not set aside or nullified by the president. Under the principle of alter ego, all the acts of the executive department or the department heads is valid. It is as if it is an act of the president. Okay, but the president himself may actually alter. Okay, so take note of the word alter, modify, nullify, set aside. Okay, so alter, modify, nullify, set aside the decision of the subordinate officers. So if it is not altered, then all the acts of those different secretaries are acts of the president under the principle of alter ego. Now, take note, the president's power over local government unit is not control. He does not have any control over the powers of the local government units. So what is the power of the president over the local government units? Who are those local government units? Province, city, municipality, barangay. Okay, the governor, the mayor, even the punong barangay cannot be altered by the decision of the president. Why? Because the president has no power of control over local government units. What is his power? It's only supervision. And what is supervision? To oversee, or the power of the authority of the officer to see, okay, that subordinates, okay, officers perform their duties. Okay, their function is only to see to it that the subordinate officers perform their duties, but as to how the duties will be performed, then it is not within the control now of the higher authority or the executive branch, because supervision is only to see to it that you do it, you do the how you're going to implement it. Okay, that you implement it, but as to how, well, it's up to you. That is the meaning of supervision. Okay, so again, the power of the president over the local government unit is only supervision, and he has no control. But as to the department heads, he has both this one, control and supervision. Okay, so when we say control, is the power to alter whatever decision of the department's heads, maybe change, alter, set aside, modify, nullify by the president. But as to the power of the mayor, governor, the president cannot alter it. His power is only to supervise, which means to see to it that the subordinate, okay, perform their duties. Now, can the president control all administrative agencies? Okay, it depends on whether the enabling statute has given the power to review to the president. So, but generally the answer, it can. But look at the laws. If the law that creates it, okay, because there are actually office that is created, okay, with their own charter, and to determine whether the president has its power is to read or see to it that their charter has an enabling law, okay, giving power to the president. Now, what is a congressional oversight power? Congress uses its oversight power to make sure that the administrative agencies perform their functions within the authority delegated to them. Okay, so there are three categories of congressional oversight functions. One is scrutiny, okay, investigation, and supervision. What do you mean by scrutiny? Okay, it is a passive process looking into at readily available facts. Okay, they can actually summon, okay, all the department heads. Okay, but again, take note of the limitations here, because even if Congress has the right to summon all the department heads, okay, take note, take note, this is a legislative branch calling upon the executive branch. Okay, so as we discussed lately, okay, there should be a demarcation line between that, okay, and one should not intervene on the powers belonging to another. But in this case, okay, under that congressional oversight function, it can, okay, but the purpose of that is only for legislation generally. Okay, so the Congress may request an information or report from other branches of the government. It can give recommendation or pass resolution for consideration of the agency involved. So their purpose, sometimes in most cases, they only summon those administrative agencies for just to exercise their power, that they are indeed in a higher authority. Okay, and sometimes it's in aid of not legislation but in aid of re-election. Okay, why? Because camera is focused on the investigation, okay, and you become famous on how you ask, how you frame the question, so that you will be, instead of paying the advertisement in the television, it's a free advertisement of yourself when you conduct an investigation over other branches. Okay, so it's a technique. Normally it can be, there are many scrutinies, many investigation, okay, during election, okay, especially if they are running for a higher position. Another is investigation involves a more intense digging of facts, Okay, power of Congress to control investigation is recognized by the 1987 Constitution, and in that the Senate or in the House of Representatives or any of its respective committee may conduct inquiries in aid of legislation. Okay, so okay, you know, even a committee, okay, ethics committee, like an alleged anomaly of Farmally, the one that I think it was the one that purchased the vaccine. Was it the vaccine? Farmally, yeah. Or so they believe there is an anomaly. So there was an investigation conducted. Okay. Actually, the heads of the office, the president, has a power not not to allow them to go to be investigated. Okay. In the case of Gloria Pagkapagal Arroyo, when generals were summoned over investigation, that was justified that they cannot attend or they should not testify on matters that are of purely belonging to the executive branch. Okay, and that power is under the residual power of the president. Meaning, if the powers are not enumerated in the Constitution, then all other powers besides with the president is called residual power. Residual from the word itself, residue, meaning remaining. Okay, so all its acts which are not enumerated in the Constitution, it's called the residual power. Now, what is supervision? Connotes a continuing and informed awareness on the part of the Congressional Committee regarding the executive operations of the administrative area. Okay? So it allows Congress to scrutinize, okay, the exercise of whether the acts or omissions complained of are related or connected with. Well, I have no battery. What's going on? Performs the official enough, okay, that the act or omission was committed by a public official. Okay? So, there are powers of the administrative agencies. Okay? One power of the administrative agencies is the quasi-legislative. Okay, the one I've mentioned. Okay, it can make a rule or a law within its sphere. Then quasi-judicial or adjudicatory. Okay, it serves as a court for that aspect only of the law passed by the administrative agency on its quasi-legislative power. And then we have the determinative powers. Okay, we go to the first one. We have the enabling power. What is an enabling power? Okay, permit the doing of an act which the law undertakes to regulate, okay, and which would be unlawful without government approval. And then we have a directing powers, order the performance of a particular act to ensure the compliance with the law, can often exercise for coercive purpose. So directing powers, meaning you have the power to really enforce the law for you to obey. Okay, and then dispensing allows the administrative officer to relax the general operation of a law or exempt from performance, okay, of a general duty. It also has the power to grant exemptions. We call it the dispensing power. Examining power, enabling the administrative agency to inspect the records and premises, okay, and investigate the activities, okay, of the persons or entities coming under its jurisdiction. So if you belong to that jurisdiction, you have to comply. Okay, so that's why there should be a permit. Okay, if you do not violate, if you violate the rules that they set, then your permit may not be renewed anymore, or the license will be revoked. Then we have the summary powers, those involving use of administrative authorities of force upon persons or things without necessity of a previous judicial warrant. Automatic, they can implement it, or even if without court approval, if it's clearly a violation of the law under its jurisdiction. Now,